Hey, and welcome back to the Michael Cohen Show, where we are now at 140,000 subscribers on our way to our initial goal of 250,000 subscribers. All right. I also want to break down for you something that I am obviously very well informed of, and that's the Manhattan District Attorney, also known as the DANY, the District Attorney of New York. You guys know it more as the hush money case. Well, Alvin Bragg's office has just written a letter, literally moments ago. Bragg's team have written a letter responding to Trump's request to delay sentencing. So let's break it down. Let's go to the first part of the letter. It's a 2-page letter where Bragg's people, and I'm talking about the district attorneys, state the following. Defendant's letter indicates for the first time his intent to seek interlocutory state or federal appellate review before he is sentenced of any adverse ruling on his CPL 330.30 motion. And again, I just want to refer to what that is all about. That is about the Supreme Court decision on presidential immunity. It is correct that the denial of immunity from prosecution is immediately appealable. But here, in contrast to defendant's criminal case in D.C., the question of defendant's immunity from prosecution is not presented. The only question now before the court is whether a small subset of the trial evidence was improperly admitted in light of a brand new evidentiary rule that derives from official acts immunity. And if so, whether any error in admitting official acts evidence was harmless. This is important now. The Supreme Court's recent decision did not consider whether a trial court's ruling on that distinct evidentiary question is immediately appealable, and there are strong reasons why it should not be. Nonetheless, given the defense's newly stated position, we defer to the court on whether an adjournment is warranted to allow for orderly appellate litigation of that question, or to reduce the risk of a disruptive stay from an appellate court pending consideration of that question. The people are prepared to appear for sentencing on any future date the court sets. Let's just go to the next part. None of defendant's remaining arguments merit any consideration. First, although couched as a scheduling request, defendant re-raises for the fourth time, my friends, a recusal grievance based on false claims of a potential conflict that have already been rejected over and over by this court, the First Department, and the advisory committee. Defendant's ostensibly new argument about the court's family members' co-workers' tweets is bizarre and has nothing to do with the post-trial schedule. And let's just show how this thing ends. Based on the foregoing, the people respectfully defer to the court on the appropriate post-trial schedule. Okay, let's take that down and let's discuss this and break it down for a quick second here. As we all know, what is Trump's defense strategy here? Delay, delay, delay. And he has asked that the court delay the sentencing until after the election, until after November. Mind you, if in fact that happens, come November, when Donald Trump loses, he will then ask for, again, an adjournment based upon the fact that he's going to appeal the results of the election. Understand, Donald Trump and accountability in his mind never equate. There should never be a line, an intersecting line, where Donald Trump and accountability, again, in his mind, ever meet. And this is a real problem, because if as Americans we believe in the Constitution, if we believe in the rule of law, how is it that Donald Trump has yet again avoided accountability? And what is the accountability here? Forgetting about the fact that he has been held accountable for 34 counts, whereby a jury of 12 have determined that he is guilty beyond a reasonable doubt in a criminal matter. So what is going on here? Well, there's a lot of mistaken statements that I see people talking about that this is Alvin Bragg. Yes, it's Alvin Bragg's office, but if you note at the very end, it is submitted by, and it starts with Matt Colangelo. It's all electronic signing anyway. Matt Colangelo, Susan Hoffinger, Conroy, the whole team of prosecutors. They're the ones that created this letter on behalf of the office. What they are really saying is that, not that we agree. In fact, we talked about that. That was the second thing that I had showed you, that they do not believe that defendants, that's Donald Trump, that his arguments merit a suspension or a delay in the sentencing. And I promise you, each and every one of us would not be getting this benefit. In fact, I'm going to give you a little personal anecdote. During the time that I had made a request for a suspension, a delay in my sentencing on having to self-surrender to Otisville, the first one I was given 90 days because I had had shoulder surgery. All right. They refused that, and then they gave me 60 days onto it. But I actually had surgery to remove a bone spur that was stuck in my shoulder girdle that prevented me from lifting my arm higher than 90 degrees. So the notion that simply because there is an issue that Donald has already tried several times and lost, including at the appellate level, that he should now be given the right to delay it yet again, right? You're talking about another 60 plus 60 days. Why? When not one of us would be given the same courtesy. Now, I understand maggots will turn around and say, but you're not running for the presidency of the United States. I get that. But he has already been found guilty on 34 criminal counts. How is it that you could then delay the sentencing on this when Judge Merchan himself turned around and said, this date is in stone. We are not going to delay this any further, knowing exactly what Trump does again and again and again. So again, what's happening here? This letter produced by the DAs under Bragg are saying, we're not going to interfere in the judge's decision. Not that they could anyway. I mean, the only thing they could have done is said, no, we don't agree, and we are opposing the defendant's motion. But I sort of get why they chose not to. They are leaving it up to Judge Juan Merchan to make the decision on whether or not the argument or arguments put forth by Trump's attorneys have any merit at all. Because, again, their goal is to now finish this case once and for all. And the only thing that remains left is sentencing, plain and simple. My position is that Judge Juan Merchan should do exactly what he said that he's going to do. There is no appealable issue here. There is no issue of fact here other than what Donald wants, and that is a delay. He doesn't want to have to go through the visual of him having to surrender yet again to the court and then be given, his card, his ID card, and so on, and then have to have a probation officer assigned to him while the matter is still pending and while he is going to still be out for the election. He doesn't know what Judge Merchan, in fact, none of us know what Judge Merchan is going to do. My only hope is that come September 18th, accountability ends and Donald Trump and the rest of the country know exactly what is on Merchan's mind when it comes to the sentencing of these 34 counts. So let's stay tuned and see what happens any day. It's also why I turn around and I end every episode by saying, Harris Walz 2024, how is it possible that somebody who is looking at sentencing, who is looking to delay sentencing, on 34 criminal counts should even be the head or the leader of one of our two parties, our political parties. Makes no sense at all. So once again, Harris Walz 2024. Vote blue. Hey everyone. First of all, thanks for watching. I mean, we're going to be posting daily episodes with reactions and talking about politics. We'll be talking about everything, in fact. So please like and subscribe. Join us on this journey.